On the phone, ladies and gentlemen, it's a pleasure to welcome back to the program the justice editor for Think Progress and the author of the forthcoming Injustices, the Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted, coming out in March of 2015. And Ian, it's as if really the Supreme Court is now functioning exclusively to make sure that your book is as poignant and relevant as possible.
As it turns out, there are five justices who want to make sure I sell as many copies as I possibly can. When I set out to write a really depressing book about the Supreme Court, I wasn't expecting them to make it even more depressing than what I wound up writing.
And it's quite possible that this King versus Burwell will be ruled upon right around that time.
That's right. So, we're probably looking a little later than the book comes out. The decision in King's probably going to come down in June. And the issue here is it could destroy much of the Affordable Care Act. It could defund much of it. And because of the way the insurance markets work, if you defund the subsidies that the Affordable Care Act provides, many insurance markets in many states will just simply collapse, and people who right now are desperately relying upon the insurance they got through the Affordable Care Act to continue their lives will not be able to get insurance at any price once those markets collapse.
Let's get to the ramifications in a second, but I want to read something that you, in fact, wrote in September. You were doing a preview of potential cases in front of the Supreme Court, or ones that you knew. At the end of the piece, you wrote, finally, there's a small but not zero chance that the justices could take a lawsuit seeking to gut the Affordable Care Act by cutting off subsidies to millions of Americans who currently enjoy subsidized health insurance under the law. This is a reference to either a Halbig, but specifically King versus Burwell. It would be highly unusual for the justices to take this case, as there's not currently a disagreement among the lower federal courts regarding whether the subsidies may be paid to all Americans who qualify. However, given the extraordinarily partisan environment surrounding all things Obamacare, it is possible that four of the court's Republican members, and it only takes 4 votes for the court to take up a case, could allow their desire to undermine this law to cloud their legal judgment. Nevertheless, such a decision would open the justices to legitimate concerns that they are placing politics before the law and potentially diminish the prestige of an institution which depends upon its reputation as a neutral arbiter of the law to maintain its legitimacy. That day just happened a couple of days ago, didn't it?
It did. They just took this case, and as I wrote back then, it's very surprising. There were none of the typical indicia for why the court generally decides to take a case. What you did have is you had a statement actually from the plaintiff's lawyer. The lawyer who's suing to try to gut Obamacare here is a very conservative lawyer named Michael Carvin, a very good but very conservative lawyer named Michael Carvin. And he was interviewed by a reporter a while back, and he said he thinks he's going to win because the Republican appointees on all courts, but including on the Supreme Court, just aren't going to agree with the Obama appointees. Those were his words, with the Obama appointees who want to uphold the law. So he sees this in a very partisan way. He doesn't have very strong legal arguments. He actually has terrible legal arguments in this case. But he does have the force of this incredible Republican outrage towards all things involving the Affordable Care Act. As it turns out, there's 5 Republicans on the Supreme Court and only 4 Democrats.
And so, all right, so let's walk us through this case. You have a great piece out, I think it was out today.
That's right.
A non-lawyer's guide to the latest Supreme Court case. And I want you to walk us through this piece because it really is reminiscent of my days as a first-year law student, and I never had any second-year law student days. So, and the upshot of this is you get a taste of law school without actually having to go or to be a lawyer. So take us through this. What does the case ostensibly hang on, and then take us through how Congress has an ability to define anything as they want to.
Sure. So what this case is about is the Affordable Care Act gives every state government a choice. The state can either choose that it wants to set up its own healthcare exchange, and that'll be the marketplace where people get to buy Obamacare insurance plans, and it's the place where if they qualify, they can get subsidies to help them pay for it. They have a choice where they can set that exchange up themselves, or they can let the federal government do it for them. And the intention of Congress was that there really wouldn't be a difference between the state-run exchange and the federally run ones. In both cases, the subsidies would exist. The plaintiffs fixate on 5 words in the statute. Those 5 words suggest that subsidies shall only be available to people who are enrolled in a health plan purchase, and these are the words, through an exchange established by the state.
Well, that's open and shut. That's an open and shut
so
case.
If you just read those 5 words, you think, oh, God, the government's got to lose this. Obviously, it's the case that, an exchange established by the state is not an exchange established by the federal government, and that's the end of it. The problem is that there's actually a whole lot more than 5 words in the law. And one provision that also exists in the law is there's another provision, and I'll just read the statute. It says, an exchange shall be a government agency or nonprofit entity that is established by a state. So any exchange, as the word exchange is defined in the statute, shall be defined as established by a state. Now, this is a weird thing that legislators do when they draft statutes, is they'll use one set of words that seems to mean one thing, and then elsewhere in the law they'll define those words that they actually mean something else. In my piece, I give an example of a hypothetical statute that defines the word dog to mean cat. And if Congress writes a law that defines the word dog to mean cat, then when a court's reading that law, every time they see the word dog, they have to substitute cat because that's what Congress has told them to do. The same thing's true here. It's use these 5 words, it's define them in a way that, may seem a little odd, but they have the ability to do that. And so the fundamental issue in this case is whether the justices on the Supreme Court are capable of reading more than one sentence. Because if they can read 2 sentences, the government wins, and it isn't even a tough case.
And I mean, this isn't just about, we hear we hear justices talk about being textualists in the context of the Constitution. But this is, this is about interpreting a statute, right? This is not about the Constitution. This is in some ways almost like interpreting a contract, too.
That's right. People throw around this word textualism. I consider myself a textualist. A textualist is someone who believes that the words of the Constitution and the words of a law matter, and you should follow what those words say. My argument, the government's argument, is just you've got to read the whole law. You can't just read 5 words and rely on those. And so taking a textualist approach, saying the only thing that matters here is the words that Congress put on paper, it is absolutely, positively clear that the law is intended to give subsidies to everyone who qualifies in all 50 states, not just to the people in states where the state opted to build its own exchange. That is in the law, and the only thing you need to do to get that, like I said, is to read 2 sentences.
And then even if you go further and you're not a textualist, right, you just look at the totality of what the intent of the law was, it's even more impossible at that point, right, to presume that that Congress meant for it to be the case that federal exchanges would not be provided subsidies, because that's like saying, that's basically the fuel that runs those things.
No, that's exactly right. The plaintiff's theory in this case is that Congress meant to give Rick Perry a red destruct button that he could push to blow up Obamacare in his state, and that they meant to pass out 50 of those buttons and give one to every single governor across the country. That's not what Congress intended to do. What happens if those subsidies go away? The way that the economics of the insurance market works is that you have to have a certain number of enough healthy people in the market, because the healthy people pay the premiums in, and then sicker people wind up using the money that's in the pool to fund their health care. If you don't have enough healthy people, there's not enough money in the insurance pool to fund its costs, so premiums have to go up. But what happens when premiums go up is that more healthy people are likely to say, you know what, I can't afford my insurance anymore, I'm going to drop it, which causes the premiums to go up even more. And this is called a death spiral, where people dropping out begets higher premiums, which causes more people to drop out, which causes even higher premiums, and so on and so forth. If you take away the subsidies, you set that death spiral in motion, because immediately after you take away the subsidies, premiums skyrocket. In Mississippi, the average premium, I'm not making this up, is going to go up 2,000% without the subsidies. So this is a road to kill the Obamacare exchanges in the states that will be impacted by this decision.
All right. Now, I mean, here's the weird part of this conversation now, right? We could start to talk about that if the 5 justices, and we have a good idea who those 5 justices would be, if 5 justices decide that they're going to strike down subsidies, essentially say that, you know, the law states that they're going to fine for the plaintiff, they're going to say that subsidies are essentially illegal in states that have a federal exchange. Let's hold off on the ramifications and what states could do to change that, and what the federal government or Congress could do to change that. But if they were being consistent, there's a whole raft of laws that they would have to revisit, right? To reinterpret, because we also have things like there was a piece in Huffington Post where someone raised the notion of 501c4s, where the actual law says you have to be exclusively engaged in social welfare as opposed to primarily, and this is what the whole supposed IRS scandal, targeting conservative and liberal groups was all around. And the IRS, because it's an executive agency, just interpreted exclusively as primarily. I mean, There would be a whole series of these things. But even having that conversation is sort of kabuki, isn't it? Because it seems like the Supreme Court is untethered from this type of examination.
Right. I mean, when you say, like, if the Supreme Court does something, it's going to create a bad precedent, and that will lead to all sorts of terrible consequences down the road, what you're assuming is that precedent still matters. And what bothers me about this case, Justice Scalia, no liberal he, is one of the court's most vocal spokespeople for the notion that you have to read a whole law. You can't just read one line out of context. You have to read the law holistically. He reiterated that point earlier this year in a case involving the Environmental Protection Agency. That's how much Scalia has cared about this point, that you have to read the whole law in the past, that he says it over and over again, even when it forces him to uphold an environmental regulation. He still claims to believe it. So if he walks back that principle now, if he says that, oh, no, I didn't actually mean that, we actually can take this one line out of context, the message that sends is that the rules don't apply to Obamacare. The message that sends is that, there's this whole breadth of law, and the court will apply this law except when they really don't like the statute, or where there's 5 justices who really don't like the statute that's involved. And that's a scary world to live in.
All right, so let's take for a moment, like, what do you suspect? I mean, I know that you Supreme Court watchers, you all get into secret rooms and talk to each other about what's really going on. What is going on? I mean, these 4 guys take, and we know that it's 4 guys. We know who the 4 are, right? It is.
We're pretty sure. We can't know for certain.
Okay, but all right. So we're vaguely guessing that it's Thomas and Scalito and Scalia and Kennedy, and they're trying to get Roberts on board with this. Is that? I mean, that's sort of what everyone assumes, correct?
Yeah, I mean, that's the most likely scenario. You know, Scalia, Thomas, Kennedy, and Alito were the four justices who said they wanted to repeal the entire Affordable Care Act, literally like undo the whole thing in 2012. So, you know, if they've already been willing to do that once, it's a pretty good sign that they're going to want to do harm to the law again. You know, what this
do they think that
Roberts
will go with them this time? I mean, because this is sort of like you said, there was a zero. I mean, not a zero, but a very small chance that they would pick this up because it's sort of it's pretty naked when there is no real sort of typical reason for them to pick up a case that is not controversial, at least in terms of the circuit courts. So, what I mean, do they think that they can get Roberts?
I mean, it's a good question. I think there's two ways to look at it. You know, one way is, yeah, maybe they're really emboldened because they think they do have him. You know, maybe they talked to him beforehand and he said that they already do have him. And, you know, that's terrible news for everyone if that's true. It's also possible, though, you know, here's the thing. Every day that the Affordable Care Act is in place, especially right now because we're about to enter an enrollment period, that means that more people get insurance. That means that more people come to get insurance that will literally save their lives. And, you know, if this lawsuit goes the wrong way, people will die who otherwise would have lived. Every single day it's in effect, there's millions of people who form a constituency for the law and will be more and more outraged if the law is struck down. So if I'm Alito and I want to kill the law, I may not know if I have Roberts or not, but what I do know is that every day I wait, it becomes harder and harder for Roberts to decide to kill the law. And so that's the optimistic take on what's going on here. The optimistic take is not that the conservatives know that they've got the 5 votes they need to kill the law. It's that they know that every minute they wait, it gets harder and harder for them to kill it. So they better take it as soon as possible because if they don't, then, you know, it's more likely that the law will survive.
So it could be essentially just a Hail Mary.
It could be a Hail Mary, and I'm hoping that they're just throwing a Hail Mary here. Because, again, you know, this isn't just a terrible distortion of the law if this goes the wrong way. And it's not just that, you know, it'll be a terrible political defeat. You know, if this law goes down, you know, I did a piece about this woman named Jennifer. She's a double lung transplant patient. She has to take very, very expensive anti-rejection drugs, and she needs insurance to pay for those drugs, or her body will reject the lungs and she'll die. You know, there was a piece by a liver transplant patient in the Washington Post that I think everyone should read. There's an amicus brief that's going to be submitted in this case on behalf of several individuals who have pre-existing conditions that need their insurance in order to live in many cases, and they're just heartbreaking stories. You know, there's a family that the gentleman had worked as a chemist his entire career. He'd done everything right. He was, you know, chemists are not people who live in the margins of society. They're people who have gotten an education and, you know, are fairly comfortable. And then he was diagnosed with prostate cancer, and then he was laid off. And what happened was because he didn't have insurance, he had to pay $2,500 a shot for routine treatments that would keep his condition at bay. I think he burned through 3/4 of his life savings that he was counting on to retire. And this is someone who had done everything right. He was 59 years old, worked his entire life, and because Obamacare wasn't yet in effect, he burned through all those savings. Now he has insurance. Now he can continue to now he can get the treatments he needs. If this lawsuit goes the wrong way, what do you think is going to happen to him when his money runs out?
Let me ask you that. Yeah. We just have a couple minutes left, and these stories. I mean, this is, you know, I mean the at least those 4 justices must have been aware, to the extent that they could be aware in the future or currently. They must have been aware of this when they tried to kill it the last time. Could this is a political question. At the very least, could, and I don't know how you get this past the House, but at the very least, you could pass it in the Senate, it seems to me, to pass a fix. Now, here's the question. You pass the fix now in the Senate. It's at least hanging there so that when this goes down, if the Supreme Court rules this way, at least from a political standpoint, Democrats can say there's been a fix waiting for 8 months on this. But if they pass a fix, could that be ammunition for the 4 or maybe the 5 to say, look, even Congress recognizes it made a mistake?
Right. Yeah. I mean, so here's the thing about it. The laws on the plaintiff side are so weak right now that, like, it's not, yes, there are things that could happen that the court will point to and say, because that happened, we're going to put that in our opinion to justify the result we want to reach. But that's what they'd be doing. The justices, if they rule against the subsidies, are going to have to construct from the ground up a rationale for what they want to do because it's not in the law.
So, I mean, just lastly, they come to you and they say, look, we can get this passed in the Senate and lame duck. You, as an observer of the Supreme Court, would we be giving cover to them, or is that sort of moot? They're going to do what they're going to do.
I mean, I think they're probably going to do what they're going to do. Now that said, what's the point of passing a fix when in the Senate, when the House won't let anything through that involves Obamacare?
Okay, fair enough. Ian, they certainly are contemplating the success of your book, which will be coming out hopefully in March. Injustices: The Supreme Court's History of Comforting the Comfortable and Afflicting the Afflicted. I'm sure we will talk to you before then, but I appreciate your walking us through this.
Thank you, Sam. And I'll point out the book is available for pre-order. If you just Google my name and Injustices,
people won't have to do that. We will link to it directly from majority.fm.
Fantastic. Well, I appreciate that.
All right. Thank you, Ian.